have a question too for Mr. Garrison when we get a spot, because he's the kind of a guru more than I am on Title VII. So.
Okay. Why don't you ask? Yeah.
Okay. There was this issue of who's a supervisor, because there's a heightened liability when the harasser is a supervisor. And we had that in our case with the trainer raping the trainee in the parking lot at Arose in the 10th Circuit, okay? Country. And in the CRST case where EEOC got sanctioned at the 8th Circuit, they held the Court of Appeals, well, I think the district court held it too, the Court of Appeals affirmed it, held that a driver trainer is not a supervisor, as I recall. That was one of the issues. And we were arguing in the other case where the trainer raped, which was in the 10th Circuit, and it looked like the 10th Circuit law was more favorably disposed towards finding anybody who could influence a hiring decision was in fact a supervisor. So could you sort of tell us where the state of the law is and do you think it's going on who's a supervisor and who's not, who would be subject to that heightened, or that at least easier to prove sexual harassment in the case of a supervisor as opposed to a co-worker?
So generally speaking, it's an interesting question, Paul. Generally speaking, not limited to the trucking industry, titles are less important than control and then power. If someone, this phrase, if you control the manner and means of production, which really is a fancy way of saying, if you're telling the employee what to do every day, and if you have the power to hire and fire, to change hours, to instruct, to require certain performance, change a schedule, to reassign, all of those are indications of control and of some sort of superior status. And so courts have said over and over that the particular title is less important. It's really what you're doing. Now, companies try to protect themselves. Sometimes they put in language, I can imagine, with a trainer or trainee, where they say that it's not a supervisor. I would think, though, and as you see, there's the difference in the circuit, the 10th and 8th Circuit. This is highly fact-specific. It also has to be, I would say, what has been published by the company, whether it's in an employee manual or given to the employee in some other written form, about what the hierarchy is. If there's a reporting chain of command that the trainee or employee knows that if there's a problem, go to someone else and not the trainer or not the particular driver, that might factor into the balance. But I do think that more and more courts are piercing the titles, they're piercing the formal structures, and they're saying who is controlling this employee, who has power, hire and fire is used, and it's, as you said, it's not just hire and fire, it's to recommend hiring decisions, right. It's to participate in it, and this gets down to a very real, practical, factual question. When this trainee is going to be evaluated, it seems to me, the person who has the greatest impact on that trainee's future is the trainer. What the trainer says.
Fail her. She doesn't pass training.
Exactly. So really, it's not just, I mean, and I would argue, if I'm the trainee's lawyer, I would argue that the company has invested in this trainer the power and duty to evaluate this trainee. And therefore, the company has delegated to this trainer the responsibility for determining the trainee's future. Now, that responsibility, what can be more control, what can be more power than that? If that trainer holds, in his hand the button, the green light or red light for this employee, that's the decision.
So you would think maybe the circuit's decision in CRST is probably an aberration to be able to drive a trainer as a supervisor.
I think so, and from what I know, there
were a lot of screw-ups in that case besides that.
Right, exactly. I think that I'd have to look at the opinion again, but that was a case where unfortunately the EEOC sort of
screwed up,
mishandled. Right, yeah, and I think there was a context of poor lawyering and of bad decisions made on the part of the workers, lawyers, that on balance probably tip things in favor of the employer and against the employee in that. But I think that, I feel in so many of my harassment cases and so many of my employment cases that if there's strong evidence of control and by an individual, even if the title is not a supervisory title, we've got a good shot. And on the practical basis, if it's going to be an issue of fact, and there's not going to be summary judgment, is the company going to want to gamble that? And I think those jurors see through the titles quickly and would be sympathetic to an employee to say, this is the person who controlled my day-to-day operations and also could make an important decision about my future.
I want to add to this. Christina's going to have a question after me. I don't know if it's in the same area, but I want to ask this related to the CRST because there's a number of companies, CRST, Covenant Transport, they do the team business model, which we really discourage new women entering to get involved in. And what it consists of is they bring you through the CDL school, you go on with your trainer, and then you have to do team driving with another student a lot of times for 6 months, which is really dangerous, and the training is horrible. It's just frightening to know you have 2 students that know nothing operating this truck 24 hours a day. So maybe they had a good trainer, and they didn't have any problems with their trainer, but now they have a co-driver that is harassing them or is unsafe or terrorizing them or is getting violent and stuff. And so some of these cases, they say, well, that's just another employee. They can't hire you, fire you. They don't have any more clout than you have. You're both equal employees, and we're not responsible for their conduct. I mean, it's like he said, she said thing, but a lot of the stuff happens between these co-drivers where one of them thinks, well, you got on my truck. I got this truck yesterday, therefore I have 1 day more.
They have a lead driver. They assign.
Yeah, they use the term lead driver, which implies to me that, and it implies to these lead drivers, I'm the boss of you. And they're really not the boss of you. It's just you got seated on the truck before the other person. So in that kind of a situation, would you still be able to have this kind of defense to say, because it's the perception is they might not be able to hire or fire you, but the perception is you're still the boss of me.
Right. So the key word here is notice and knowledge. I would advise in that situation for the employee who has a problem complaining, immediately notify the company. Once you put the company on notice that this coworker is harassing you or doing something that is wrong, the company's responsible. The standard usually is knew or should have known. So should have known gets harder to prove that even though I didn't inform the company directly, this was happened over such a long period of time, it was so open, there were circumstances in which the company should have known about it. Trucking context, I think that's hard to claim because you're out on the road. But just an email, a written complaint, not oral, something that, or if the company has a hotline, make the complaint, so that once the company is informed of the co-worker's conduct, the company now knows, and if they don't do anything, they're endorsing it, they're ratifying it, they're adopting. Beyond that, I will say that again, if the facts show that this lead driver has some power, has some impact on the driver's or employee's future, I think you have an argument. I will say, in my opinion, without having seen the individual facts of any particular case, I think it's an uphill battle. It's a pure coworker to hold the company liable without notice. So my first advice is, if there's bad stuff going on, tell the company, put it in writing. Sadly, that typically is ignored. Mm-hmm. But once you're on record and you notify the company, you've got the company on.
Okay. Because you have the paper trail.
Right, and they know.
Okay.
And they ignore it. They fail. They fail to Once they know and they don't take action and there's subsequent harassing conduct or
Retaliation for reporting it, which we feel
well,
like.
that's something else. Retaliation is a whole other, that's a separate claim. That's a separate claim. If there's retaliation for reporting it, that's a whole other legal claim. And just want to say one thing. Juries and courts, statistically proven, really respond favorably to claims of retaliation. When an employee complains and then a company punishes them in some way, juries get that. I think it's just common sense that people understand that companies don't like it when employees complain, especially if they raise uncomfortable words like harassment or sexual harassment or discrimination. And if you're punished for that, statistically it's proven juries are more likely to rule in favor of the return a verdict in favor of the employee than almost any other area, whether it's sexual harassment or discrimination or based on race or religion. If you have a claim of retaliation and it's a real claim, bona fide, the likelihood of success is strong.